Namaste Bharat. My name is Disha Kothari, intern at Law Chamber of Siddharth Murarka, and today's webinar has been hosted by me. Today we have a speaker, Dr. Satya Prakash Khatana, Joint Secretary, Ministry of Parliament Affairs and Advisor, Law Competition Commission of India, and he will be speaking on today's topic, that is the competition law, key features. Now I hand over the session to Shri Dr. Khatana sir for enlightening his vast knowledge and experience on the said topic. Thank you, sir. Now you can take over the session.
Thank you. Am I audible?
Yes, sir.
Yes, sir.
Good afternoon to everybody. I have been asked to speak on the competition law, its key features. First of all, I would say that I am not an expert of competition law or law as such. I am simply a student of law. Still, I consider myself to be a student of law. But I have worked in this area of law for more than 5 years, from 2009 to 2015, and I have handled all litigation of Competition Commission of India before all forums, Competition Appellate Tribunal, different high courts, and Supreme Court of India. So whatever experience I have gained during that period, I will be sharing with you. This is a new law in the sense that Competition Act was enacted in 2002, but it came into force in full bloom in 2009 only, because it was into litigation just after enactment in 2003. In 2007, certain amendments were, you can say, made in the law, and thereafter in 2009, with the notification of its provisions relating to anti-competitive agreements and abuse of dominance on 20th May 2009, this Competition Commission of India became operational, and some of the important provisions of this law became applicable and started for its implementation. Thereafter, in 2011, its provisions relating to regulation of combinations were also notified, and now since then Competition Commission of India is fully operational. And during these 11 years, Competition Commission of India has dealt with about 1,000 cases relating to anti-competitive agreements and abuse of dominance by different enterprises, and more than 850 advocacy initiatives also they have taken. And they have also approved combinations, about 700 combination cases they have so far approved. And that way, Competition Commission of India has done a great job against the other regimes where competition law is as old as 100 years, and we are only 11 years old in this field. And this is a very new field, very challenging field for advocates also. And so many advocates are taking up this challenge, and that way our capacity is getting build up day by day. Coming to this law has got its genesis in Directive Principles of State Policy, particularly Article 39 of the Constitution. And we have the first law, Monopolies and Restrictive Trade Practices Act 1969. You all know that law basically put emphasis on curbing monopolistic tendencies, basically. And this law is, you can say, contrastingly says that matter, you can say a size of an enterprise is not a problem if economies of scale are being percolated to the common public. These days, big enterprises are not problem, their size is not a problem, but in case they abuse their position, that is a problem, and that is considered to be anti-competitive in terms of our law. The basic objectives of this law are prevention and elimination of anti-competitive practices from India, economic development of the country, sustenance and promotion of competition law, basically competition within the markets in India. Then economic development of the countries. Besides that, consumer interests are very important, and freedom of trade. These are the basic objectives of this law. These are the purposes for which this law was enacted, and that that is what for this law was enacted. This law is based on market forces only. After the concept of LPG being adopted, liberalization, privatization, and globalization, we are now in a free market kind of economy where prices are determined by demand and supply. And you can say there are no controls. Efficiency is the criteria on the basis of economic actors are supposed to work. And when efficiencies are the criteria, then obviously innovations happen. And with the innovations, you can say economic actors get reasonable price, reasonable profits, and ultimately people get cheaper products at competitive prices. What competition is? First of all, we have to understand what is competition. This word competition has not been defined in this law, and rightly so. But there are certain terminologies used in this law which are appreciable adverse effect on competition and abuse. And these are the two terms which tells us what is anti-competitive. This law basically deals with ex ante and ex post enforcement of the provisions. Like some anti-competitive things have happened and they are required to be rectified. Those kind of conducts are considered to be ex post. Like section 3 says, all agreements having appreciable adverse effect on competition are void, are considered to be bad. In the same way, section 6 of this act says that combinations, mergers, acquisitions, amalgamations, if they are entered into between the parties and there is likely that after they combine, they come together, there will be appreciable adverse effect on competition, then those kind of combinations are also bad. And in the same way, in section 4, abuse by dominant players in the market has been prohibited. All these prohibitions are basically anti-competitive practices, are conducts which are considered to be anti-competitive. So what is anti-competitive and what is not anti-competitive is competition, in other terms. And with the passage of time, what is competitive, what is not competitive has been left on Competition Commission of India and our judiciary to decide from time to time, keeping in mind economic development of the country. Now, before coming to the main provisions of the Competition Act, first of all, I would like to share with you some definitions. Most important definition is agreement. Agreement includes arrangement, understanding, or action in concert that may be formal in writing, whether or not intended to be legally enforceable. It means mere arrangements, understandings which may not be in writing, which may be just oral, which may be legally enforceable, which may not be legally enforceable. Those kind of understandings, arrangements are also within the definition of agreement. Now, enterprise. Enterprise means person. Person is quite elaborately defined in this law. Person and government departments have also been brought within the definition of enterprise. All persons, government departments, engaged in different economic activities, but excluding the government's functions which are relatable to sovereign functions, are considered to be enterprise. They fall within the definition of enterprise. You can see very elaborate, you can say, definition is there of enterprise in this law. Then relevant market will be frequently used in this law. Relevant market has got two components: relevant geographic market and relevant product market. What is relevant geographic market? Relevant geographic market means market comprising of area in which conditions of competition for supply, demand of goods and services are distinctly homogeneous and distinguishable from neighboring areas. Means within a territory, as regards conditions about these services and demands, some distinct features are there. That territory will be considered to be a relevant geographic market. Then relevant product market, a market comprising of all products and services which are substitutable and interchangeable for each other for reasons of their characteristics and intended use. All those kind of products and services will be considered to be a single product. Keeping these two aspects in mind, relevant market is determined, and anti-competitive conduct has to be assessed within relevant market. So these definitions are very important for dealing with competition cases. Then consumer. The word consumer has been defined in such a way that consumer, as defined in consumer law, if they purchase some product for end use for consideration, here the word for commercial use has also been used. That way, the definition of consumer is, you can say, bigger than what is mentioned in the consumer law. Now coming to basic provisions of this law. The first and most important function of this law is prohibition of anti-competitive agreements. All agreements having appreciable adverse effect on competition are considered to be bad, prohibited. They have been declared to be void. Anti-competitive agreements have been defined, or you can say categorized, in two you can say kinds, basically: horizontal agreements and vertical agreements. There is no such nomenclature in the act, but keeping in mind their nature, this kind of classification has been made. Agreements entered into between and among two or more enterprises, persons operating at same level of business, are known as horizontal agreements. Section 3(3) of the Act deals with horizontal agreements. Means when people working at the same level of business are entering into some kind of agreement, like if producers are there, all producers coming together comes for a agreement, that will be called to be an agreement of horizontal kind of nature. Cartels, bid rigging are this kind of agreements. Horizontal agreements have been considered to be void ab initio, and presumption of appreciable adverse effect is presumed just on finding that there is some kind of agreement. So here onus shifts to the parties to the agreement to prove that their conduct is not anti-competitive, their conduct is not creating appreciable adverse effect on competition in markets. There are so many cases Competition Commission of India so far has decided on this, and you can find details at the website of Competition Commission of India. One more important thing I want to tell you, that joint venture agreements are also agreements which may fall under horizontal agreements, but if they are creating efficiencies in the market, then they are exempted from, you can say, prohibition under this law. International studies say that bid rigging increases prices from 20 to 40%. That way, in case we deal with these cases, then how much savings we can make, that kind of idea we can have. You all know that world over, public procurement is a big issue. In India, we spend 30% of our GDP on public procurement. If all government departments implement this law in letter and spirit, we can make a lot of savings. World over, this spending is on an average 15% of their GDPs. Now coming to the second part of anti-competitive agreements, vertical agreements. These have been defined under section 3(4) of the Act. These are the agreements which are entered between and among enterprises operating at different levels and stages of production and demand chain of goods and services. For example, mobile service requires mobile handset producer and mobile service provider. And if they enter into some agreement, that will be known as vertical agreement. That is another thing, whether that agreement will create appreciable adverse effect on competition or not. That has to be seen on the basis of rule of reason. Here in these kind of agreements, presumption of AEC is not drawn straight away. Here, DG and Competition Commission of India has come to a conclusion on the basis of a record that appreciable adverse effect due to this kind of agreement is there in the market. Only then they can say that particular agreement is violative of the provisions of this law. So there are certain exemptions to section 3 in totality also. All agreements exclusively for the purposes of export have been given exemption. Then usage of IPRs. If we are using, we are putting reasonable conditions and then enjoying our IPR, then those enjoyment of IPR is also exempted from the purview of this law. Famous car case is an example, and there are so many examples there which you can see from the website of Competition Commission of India. Now coming to the second provision of this law, abuse of dominant position. Section 4 says that enterprises abusing their dominant position in market is prohibited. So first of all, there has to be an enterprise which is doing economic activity. Then that enterprise has to be dominant in a relevant market. As I told you, in relevant geographic market and relevant product market. That is basically the relevant market as a whole. Then that dominant enterprise should be abusing its position in that relevant market. And if that is proved by commission, only then we can say that some enterprise is in violation of the provisions of competition law. Dominance, there are certain factors mentioned in the law for proving dominance of an enterprise in a particular relevant market, which are mentioned in section 19 subsection 4, which you can see elaborately there. Abuse of dominance has been clearly defined in section 4 subsection 2, which says that dominant enterprise may put unfair discriminatory conditions, purchase or sale of goods, services, prices including predatory pricing, limiting production, supply, denial of market access, etc. One example I want to give you, that of predatory pricing. Suppose there are two enterprises in the market, and both enterprises are producing same product. One bigger enterprise has got deep pockets. They have got a lot of resources. And if that bigger enterprise start using its resources for leveraging that benefit and start, you can say, determining the prices of its product below cost price and start selling in the market, its competitors may go out of the market. And after their exit from the market, he can misuse that position and he can fix any prices of its product. That kind of practices are prohibited under this law. DLF case is a famous case which Competition Commission of India has dealt with, which was, you can say, approved by Competition Appellate Tribunal and now pending in Supreme Court of India. And there are other cases also. And I have forgotten to tell you that there is no distinction for Competition Commission of India or competition law to distinguish about the working of a private entity or a government entity. And Competition Commission of India has imposed 1,773 crores penalty on Coal India under abuse of dominant position on an application, on an information being filed by Maharashtra State Power Generation Company. That is an example. Now, I would like to tell you how the cases relating to anti-competitive agreements and abuse of dominance can be filed, where and how. First of all, I would like to tell you that application or petition is known or nomenclatured in this law as information. And that is with the intention. Because competition law is basically in the public interest. And there is no requirement of locus standi for someone to file some petition or application in Competition Commission of India under this law. So intentionally, the word information has been used for petition or application kind of things. Who can file information? Any person can file information. There's no requirement of locus standi. Then, obviously, with requisite fee. And when it comes to fee, if individual wants to file an information, he is required to pay 5,000 rupees. If some NGO is filing some information, they are required to pay 10,000 rupees. If entity below 2 crores, if some entity or you can say some firm or company is having turnover of less than 2 crores, if they want to file some information, they have to shell 50,000 rupees. If some company having a turnover of less than 50 crores, then they are required to pay rupees 1 lakh as fee. And maximum fee is 5 lakh for enterprises having turnover of more than 50 crores. Central government, state government, and statutory authorities can make references without any fee to the Competition Commission of India. Then Competition Commission of India has also got power of taking up cases suo moto. They can take up cases of their own. They keep on having studies done in different fields. They keep on investigation, keep on working. And if they come to a conclusion that yes, there is some case there, then they can take up the case of their own also. And for that purpose, they have prepared one anonymous module, and that module can be used by one and all, can be used by anyone. If they are having some information without disclosing their name, they can, or you can say, file that information on that module, and that will be processed by Competition Commission of India. And if they feel that sufficient information they have collected, then they can, you can say, makes prima facie opinion also on that aspect. Information is to be filed to the secretary, to the commission, with requisite fee. These days, e-filing facility is also available. Then what is the procedure after, you can say, information is received in the commission? That information is processed in the commission, preliminary examination is done, analysis is done, and if commission feels that sufficient information is there and there is a case which requires further investigation or detailed investigation, then opinion, prima facie opinion can be formed under section 26(1) for investigation by DG, and matter can be referred to DG for detailed examination. That order under section 26(1) is not appealable. If commission comes to a conclusion that the case is required to be closed, then that order is appealable. Commission refers the matter to DG. DG investigates into the matter thoroughly. DG has got power of a civil court for having information from relevant parties. He follows principles of natural justice. And ultimately, he gives report to Competition Commission of India. Competition Commission of India shares that report with relevant parties. Here, relevant parties have expert opinions if required, and ultimately passes some order. And that order can be closure of that case, can be in case commission comes to a conclusion that there is violation of either section 3 or 4, then commission may pass order for cease and desist. Commission can also impose penalty, and penalties are very severe, up to 10% of average turnover for last 3 preceding financial years in respect of vertical agreement cases and abuse of dominant cases. And penalties for cartels are even more severe. Penalty up to 10% of turnover or 3 times of profit for each year of continuance of such agreement, whichever is higher, can be imposed. Commission can also pass orders for modification of the agreements which are found to be in violation of the law. Then if commission comes to a conclusion that some enterprise is abusing its position in the dominant market, then division of that enterprise can also be ordered by commission under section 28. Commission also has got power of passing entering orders, that too without hearing opposite parties in exceptional circumstances. Then coming to its third, you can say, limb of enforcement provisions, that is known as regulation of combinations. Regulation of combinations, section 5 defines what combination is. Merger, acquisition, amalgamation, all these fall within the definition of combination. And then certain turnover and you can say assets and turnovers are the criteria on the basis of which we come to a conclusion that what entities, if they are coming together for combination, are required to notify their combination to the commission. If those thresholds are met, then they are necessarily required to notify their combination to commission, and commission has to examine that. Section 6 of that act says that if combinations are likely to have appreciable adverse effect on competition, then they are prohibited. All cases, combination cases, are necessarily required to be approved or disapproved, or some decision has to be given by commission within 210 days. Otherwise, that combination is deemed as approved. This limit of 210 days has already been decreased by Competition Commission of India through regulations by imposing, you can say, self-restriction to 180 days already. And now in recent proposed amendments, which are at consultation stage, they are saying that they should be further decreased to 150 calendar days. Factors for determination of appreciable adverse effect on competition through combinations have been mentioned under section 20, subsection 4, which you can see in detail. Combination cases can be filed by parties to the combination, and sometimes Competition Commission of India of their own can also take up the cases if they are not reported and if they are reported wrongly. But one rider is there that inquiries by commission in combination cases cannot be initiated if combination has taken effect 1 year back. 1 year limit is there. Within 1 year, they can take up cases. Otherwise, they will not be able to take up cases in old cases. Combination cases can either be approved, or they can be approved with modifications, or they can be rejected straight away. Most of the combination cases are approved by commission at preliminary stage itself. These days, from last year, commission has come up with green channel automatic system. Some regulations have been framed, particularly with relation to the combinations or where parties are not having overlap kind of businesses. Suppose parties are into different kind of businesses and they are coming for a combination, then they can use this channel and they declare that there are no you can say competitive concerns and they can go ahead. Competition Commission of India will keep on examining the issue and they can take action if required. Otherwise, they in 99% or 100% cases there will not be any competition concern. And you will be happy to know that more than 30% cases from last year have been approved in this fashion. And average taken time by Competition Commission of India so far in approving combination cases is only 18 days. When this regime was adopted in India, there was criticism that whether this law has been brought for bringing ease of doing business or for stalling the business, because you have created one another mechanism where approval of combinations will be required. But Competition Commission of India has proved that they are not an obstacle, but they are doing their regulatory work very efficiently. One more system, you can say electronic system Competition Commission of India has come up, that is DIV, do it yourself, for helping combining parties to know whether they are required to notify their combinations to the Competition Commission of India or not. That kind of check they can have, they can do of their own. Besides that, they can also come and meet Competition Commission people. They are expected to guide them. There are so many orders passed by Competition Commission of India on this aspect, which are available on the website of Competition Commission of India. The last function of Competition Commission is advocacy, and that is very important. These competition advocacy provisions were the first provisions notified way back in 2003. And from 2003 till date, Competition Commission of India is doing this work diligently. It is a very special provision which authorizes Competition Commission of India to tell the stakeholder of competition law what competition law is all about, how this law is to be enforced, how this law is to be followed. So emphasis is more on advocacy than on enforcement. Section 49(3) basically deals with advocacy provisions. In that very section, central government, state government, and statutory authorities have also been given power to have opinion from Competition Commission of India on policy issues. Competition Commission of India is obliged or required to give opinion within 60 days. That is another matter, that whether they accept it or not, it depends upon them. But in most of the cases, if matters are referred by them, advice is also accepted by them. Now coming to some important other provisions of this law. Sectoral regulators and relation with them are governed by section 20 and 21A. Statutory authorities can refer their matter to Competition Commission of India in relation to some competition concerns, and Commission is bound to give them opinion within 60 days. And after having opinion from Competition Commission of India, they can decide their cases as per their existing law. In the same way, matters Commission can also refer to them, and they will be giving opinion to Competition Commission of India, and Competition Commission of India can go ahead with decision after taking into note the advice given by them. Competition Commission of India also has got extraterritorial jurisdiction. If enterprises are working world over and working somewhere else, and their presence is also there in India, and impact is felt in India, then Competition Commission of India has got power of taking action against such enterprises. That kind of provision is also there in our law. Then leniency provisions. You all know that cartels are considered to be most pernicious horizontal agreements, and it is very hard to break cartels. For breaking cartel world over, leniency kind of provisions have been adopted. In the same way, we are also having provision for leniency under section 46, and we have also come up with leniency regulations, and under those regulations, enterprises giving complete relevant information to Competition Commission of India and DG and helping them throughout can be given leniency up to 100% penalties likely to be imposed upon them. Then confidentiality provisions are also there. You all know that economic actors have got some very confidential information relating to their trade secrets or IPRs or their trade strategies, which they may not like to disclose to anyone, particularly to their competitors. So for maintaining that confidentiality, there is a provision in this law under section 57 that such information cannot be disclosed to anyone without permission of the party. But exemptions are also there. That information can be used for the purposes of competition law and for the purposes of any other law for the time being in force in India. But obviously, you can say maximum care will be taken that that confidential information does not get leaked, and with which you can say some damages may happen to enterprises. Initially, after orders being passed by Competition Commission of India, its appeal were lying with Competition Appellate Tribunal. You all know these days that forum has been replaced by NCLAT. Now within 60 days from passing of an order by Competition Commission of India, an appeal can be filed in NCLAT. And Competition Commission of India is a necessary party in the cases where suo motu cognizance has been taken by Competition Commission of India. And in other cases, not pro forma, but proper party. Competition Commission of India is proper party in all other cases before all appellate authorities. One very important provision in the form of section 53N is there in this law, which gives power of award of compensation to the people who are victims of anti-competitive conducts by enterprises in the market. It is a kind of class suit provision. This law has not been used so far by anyone, but in future, obviously, it will be used. I would like to discuss in nutshell, you can say in short, one very important judgment, Competition Commission of India versus Steel Authority of India. In this case, appellate authority, compared at that point of time, held that prima facie opinion formed by Competition Commission of India is also appealable, which was against the statute. We carried that case to in appeal before Supreme Court. Supreme Court had thorough examination of complete law and said that appeal is a statutory right, and this 26(1) order of Competition Commission of India cannot be said to be appealable. Competition Commission of India, the Supreme Court also held that Competition Commission of India will be necessary party in suo motu cases and in other cases proper party. Then Competition Commission of India has rightly got power of making, or you can say forming prima facie opinion without hearing opposite party. And in exceptional cases, Competition Commission of India also has got power of passing order, interim orders without hearing opposite party. But that power has to be used sparingly by Competition Commission of India. Now, I would like to, you can say, discuss some proposed amendments to this law, which are at consultation stage as of now. Government is conscious that this law should be dynamically changed from time to time. Two very important amendments proposed in relation to combination cases are: one is the outer limit for approval of combination cases is proposed to be reduced from 210 days to 150 calendar days. Then another provision is relating to issue of statement of objections by commission. If commission comes to a conclusion that they are having some objections, if some case is to be carried to, you can say, thorough examination, then they can issue statement of objections, and parties to the combination, after taking note of those objections, can give revised proposal for modification in the combination. That kind of provision is likely to be introduced, and only after approval of Parliament we can say something about that. And definitions of cartel and vertical agreements are proposed to be made more, you can say, comprehensive by including demand aspects also, which are, you can say, missing as of now. Then exemptions of agreements relating to exclusively exports and IPR exemptions are proposed to be extended to abuse of dominant cases also. Presently, these exemptions are available only under Section 3 in cases of anti-competitive agreements. Then one concept of governing board, by making commission a, you can say, broad-based organization, is likely to be introduced, and all the administrative powers, regulation making powers, advocacy powers are proposed to be exercised by that governing board. Commission is also being criticized for not coming up with the quantum of penalty provisions, and that kind of provision is also likely to be introduced in this law, and then Competition Commission of India will be bound to issue guidances how they will determine quantum of penalty on contravening parties. One more provision relating to 25% of penalty amount deposition or any other amount as may be prescribed by law as a precondition for filing some appeal before for NCLAT and later on before Supreme Court is also proposed, and that depends how we can say things will happen. Then in respect of cases relating to vertical agreements under Section 3(4) and cases relating to Section 4, abuse of dominant cases, concepts of settlement and commitment for speedy disposal of cases, for early correction in the markets are likely to be introduced. As regards settlement, once order under section 26(1) is passed for prima facie opinion and thereafter DZ's report has come, at that stage, before passing of an order, settlement kind of proposal or application can be
you can say in the whole system there, and we are in, you can say luthiers. Even then, the problem has occurred. For the first time, I have seen this. Now, I was telling you that about the concept of settlement and commitments, and if these are introduced, then cases relating to section 3, 4 vertical agreements and abuse of dominant cases will be disposed of in a fast manner. And you can say if orders are passed by Competition Commission of India under these provisions, then those orders will not be appealable. In the end, these you can say settlement and commitment provisions will not be obviously applicable to cartel cases. Now, in the end, I will conclude by saying that competition law is a law which is must in the present conditions of the country with the free economic kind of concepts. And this is the law for the future. And this is the law for development of the nation, for bringing efficiencies into play, promoting innovations will always be there, because when enterprises want to make reasonable profits, they are obviously competing with each other. And the purpose of competition law is not to promote competitors or protect competitors, but promote competition. Only efficient players are expected to be there in the market. And the purpose of the law is basically that there should not be any entry barriers in the market. Freely, enterprises should be able to come in the market, and they can exit the market if they are not efficient, if they are not able to, you can say, maintain their competitiveness in the relevant market. And this law is also very important for ease of doing business. And this law is not only for helping economic actors, but you can say people as a whole. You can say all consumers are the beneficiaries of this law. Thank you very much. This is in a nutshell what I wanted to speak to you about this law. And I have tried to be very brief. I have not, you can say, dealt with any of the aspects in detail. And that can always be, you can say, spoken at some point of time if required. And we can discuss this law. Thank you very much. If there are any questions, please let me know. I will try to, you can say, respond to them. And if I will not be having answer for certain things, then I will revert back, obviously, to whosoever put some question. Neeraj, can you hear me?
Yes.
Yes,
sir.
Yes, ma'am.
So there are a few questions. Hello.
Yes, I can hear you. You please put your question.
Okay, sir. CCI can increase the scope of investigation into anti-competitive practices as per requirement. Can the Director General do the same?
No, Director General does not have got that kind of power. Earlier, under TPC regime, DG was having power of making cases. You can say sumo moto cognizance he could take at that point of time. Now, under this regime, DG does not have got that kind of power, and only Commission has got power. Commission can take up cases. They can make references to the DG for thorough investigation, but Commission of its own cannot take up any cases. Sorry, DG cannot take up any cases. Commission can.
Okay, next question. What factors Competition Commission should take into consideration determining whether an enterprise enjoys dominant position or not?
Okay, those you can say factors you can see under section 924, 20 subsection 4. Let me read it for your benefit. Yes, under section 19.4, you will see that commission shall, while inquiry whether an enterprise enjoy a dominant position or not under section 4, have due regard to all or any of the following factors. The factors have been clearly mentioned there. The first factor is market share of the enterprise, then size and resources of enterprise, size and importance of the competitors, economic power of enterprise, including commercial advantage over competitors, vertical integration of enterprises, or sale or service network of such enterprises, dependence on consumer on enterprises, and so many, you can say, factors are there. And on those, on the basis of those factors, Competition Commission of India can come to a conclusion whether some, you can say, enterprise is a dominant enterprise in some relevant market or not. And these factors are not, you can say, the only limits. With the passage of time, the nomenclature or provisions of law are such that. Can you hear me? Your voice is not coming.
So now your voice is coming, but your video is not coming proper, sir.
Okay. Now you can hear me?
So we
Yes, we
can
can
hear
hear you.
you.
Yeah, and whatever reply I gave, that you could hear or not? No.
So how of the report has not been heard by you? Not been heard by us.
Okay. Actually, I think problem is there with the phones. You can say. On the basis of which an enterprise is considered player in the market. Those factors are mentioned in section 19, subsection 4. They are Am I clear?
Yes, sir.
Okay. Then any other question?
Next question. The Competition Act 2002 is drafted on the lines of European competition law. How far are the decisions of the EU Competition Authority accepted in India? Also, is there any influence of the decision of the US Federal Trade Commission on CCI?
Very good question. If you say that certainly influence of European law and laws of different countries is there on our law, but this is not an international, you can say, law. It is a national law, and our parliament has passed this law, and provisions of this law are framed in such a way that they meet the requirement of our country, and some of the provisions have also been modified in such a manner. And obviously, when we are passing orders, Competition Commission of India is passing orders, they take into cognizance whatever jurisprudence has been developed world over, but the same kind of orders can never be expected to be passed. Obviously, you can say we will be taking into consideration how they have dealt different situations, but and we are not expected either to follow the judgments passed by other countries. But we have to live in this world, competitive world, where you can say enterprises are working across nations. in the world. So homogeneous kind of jurisprudences have to be there world over. But you can say, strictly speaking, I will never be commenting on that, whether we are following their judgments or not, and that is not also expected. We are having our own conditions, and our orders are also according to the needs of our own present or national needs and conditions.
Okay, sir. So next question.
Yes.
Whether Jio's policy of offering network services for free in the initial phase to attract consumers would come under the ambit of predatory pricing under the Competition Act?
I think this case came up before Competition Commission of India, and they have already passed order. And for me, it is not, you can say, prudent to make any comment, even if I am having some personal opinion, because I'm also an officer of government. And besides that, I'm also an officer of Competition Commission of India. For me to comment on this kind of issues is not prudent. I will never be commenting on that, even if I am having some other opinions.
What are the provisions for appeal against any order of CCI?
Appeal. I have told you that all orders, appeal is a matter of statutory right. And Competition Commission of India, in competition law, provisions have been specifically made. What orders of Competition Commission of India, orders passed under different provisions of law, they are appealable. Only orders relating to prima facie opinion formed at the stage of the section 26(1), where Commission refers the matter for detailed examination to DG CCI. All orders are, you can say, which are in the nature of finality are appealable, and specific provisions are there in the Act. And there is no ambiguity about it. And this is also established jurisprudence that appeal is a statutory right. If some statute gives some right somewhere, only then appeal will lie. So there is no dispute about it. Our law clearly provides for that.
Okay, next question. In a significant judgment for the purpose of levying penalties, the Supreme Court interpreted total turnover as relevant turnover on the grounds of equity despite the provisions of the competition law being clear. Sir, your thoughts on this view?
Yeah,
I mean, this question.
I think you are putting that question in some other words. You can say competition, the Supreme Court has said that Competition Commission of India should be interpreting these provisions in some different way. Supreme Court has reduced the penalty, and Competition Commission of India is following that. And in respect of that, you can say some amendment is also proposed in the amendments which are at consultation stage as of now. Only Competition Commission of India can tell about this, because presently I'm not there. I will not be commenting on that aspect also. How they are doing and what they are doing and how they will proceed. But Supreme Court has reduced the quantum of penalty, and they have made certain observations. And when Supreme Court, you can say, makes some observation and gives judgment, Supreme Court is the highest court of India, and Competition Commission of India is obviously bound to follow that.
Last question, sir. Does the whole issue regarding non-complete clauses fall under the sphere of competition law? If yes, what is the position in India with respect to such clauses?
But for me, it is not, you can say, prudent to comment on that aspect as of now, because I'm not, you can say, privy to what is happening in that field. So for me, I will, you can say, avoid making any comments on that aspect, because presently I'm not working, and I in the competition law and with Competition Commission of India as of now, and I don't know how they are taking up that issue and what is the position. So no comments.
Okay, sir. With this, we come to end of our lecture. Thank you, sir, for enlightening us on today's topic. It was indeed a very informative session for all of us, and I'm sure the same will be surely help us in uplifting our profession to the new heights. We are looking forward to have many more sessions by you in the near future. Thank you, sir.
Thank you very much. Thank you.